Your Honor.
I need people to sit up straight. This is inappropriate. And I'm sure I said this previously. Okay, well, perhaps you could ask, you all didn't ask that in the breakout room to the person who's with them? Oh. Okay.
I don't really know if there's anybody with.
Yes, it is. I saw somebody. I saw two people on the couch.
Okay.
Oh, okay.
You can't make this up.
Welcome back to Time Served, the channel that scans the docket so you don't have to. I am going to keep this short and sweet and break it down to its most simplest terms. Do not lie to Judge Bryant under oath. It will not end well for you. So please, if any of you end up in front of Judge, heed this same warning. Tell us what you think or just say hello by commenting down below. Like and subscribe, set your notifications to all. Let's roll, nerds.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, I do.
You may put your hand down. Who's going to voir dire Mr. Hunt with respect to the factual basis?
I can't judge if that's okay with the court and defense counsel.
I said, yes, sir, fine with me.
You may.
Thank you. Mr. Hunt, on June 17, 2022, were you operating a motor vehicle on northbound M10 Service Drive and West Grand Boulevard?
Yes, I was.
Is that the city of Detroit?
Yes.
Is that the county of Wayne?
Yes.
And while operating a motor vehicle on North M10 Service Drive, strike that. Prior to operating a motor vehicle, did you consume any alcohol?
Yes.
And did the consumption?
Before I was driving, I did consume a beer at the bar. Yes.
Okay, and did the consumption of that beer impair your ability to safely operate that motor vehicle?
Yes.
Mr. Moore, you cannot answer for your client. Now, first of all, nobody's going to make me believe that the consumption of a beer impaired his ability to operate a motor vehicle. So we're going to go back. We're going to dial it back. Otherwise, I'm not going to accept this plea. And we're going to either tell the truth, the whole truth, and nothing but the truth. And if that is the truth, because it's possible that it's the truth, that he drank one beer. Okay, listen to it's possible that it's true that he drank a beer, but it's not possible that that beer impaired his ability to operate a motor vehicle. Now let's go back again. What did he have to drink before he operated the motor vehicle?
I had a beer. I was at the bar watching the game.
All right. I'm not going to accept I'm not going to accept the
ma'am.
plea.
Your Honor.
I need you to let me do my job.
Okay.
I'm not going to accept the plea. I need discovery to be sent over to Mr. Moore. I need to see what his alleged blood alcohol was after he consumed the beer. And then we're going to look into it from that perspective, because I've never in the history of my life known a person to be impaired after consuming a beer. Okay?
Yeah,
okay, ma'am.
Let me tell you this, sir. Don't keep talking to me.
Okay.
Yeah, I have had discovery, and I reviewed with them that the results were 0.166.
Well, then, if that's the case, then your client is lying on my record. So let's be clear.
Okay.
If that was his blood alcohol level, then your client, under oath, I swear to tell the truth, the whole truth, and nothing but the truth, so help me God. If that is his blood alcohol level, then your client is not telling the truth on my record.
Your Honor, I'm going to say this. Okay.
I don't understand why there's conversation with me and your client while I'm trying to take a plea. That's what I don't understand. Now, the question was asked, what did he have to drink? Your client said he had 1 beer. So either there's something, the math isn't mathing. Something is not right. And I'm not going to just take a plea for the sake of taking a plea. Either he's guilty or he's not guilty. But if he's not guilty, then I'm not taking a plea. We're not, no.
Sure. Well, that's fine. I talked to you.
So do we want to go back to what did we have to drink? I mean, I don't know.
Yes. Tell me yes.
He said yes. You got to tell him what you had to drink.
Okay. I had more than 1 beer, Your Honor.
Ms. Ritter, you can continue.
Thank you, Judge. Mr. Hunt, and did the consumption of those alcoholic beverages impair your ability to safely operate a motor vehicle on that day?
Yes.
And Judge, for purposes of the plea, the people stipulate to the blood alcohol content of 0.16, and with that, the people are satisfied.
I'm also satisfied, Your Honor.
Let me tell you all something. If I'm not serious about anything, I'm serious about 2 things. One of them, they don't let me discuss in my judicial role. That's my number 1 thing that I care about. The thing that they tell me that I have to separate. The second thing is I take this job, this courtroom, and this process seriously. Now, what I could do is have Mr. Hunt charged with perjury, but I won't because maybe he was a little confused. But what we know is that he lied today on my record, under oath. What we know is, looking at Mr. Hunt, a child could drink a beer and not have a 0.16 blood alcohol. We're not even talking about a 0.06. We're not talking about a 0.08, barely the legal limit. You sitting up here telling me it's a 1 in front of his number, and he got on my record under oath and said all I had to drink was a beer. That's insulting to the court. Your credibility is shot. And it's clear to me that at somewhere in your life, you living in a denial. You living in a denial somewhere. Now, I don't know if you drank a beer and the glass was as tall as you. But if you're going to tell me you blew up, what was the blood alcohol?
0.16.
You blew a 0.16 after you drank a beer. You shouldn't drink nothing else in your entire life, because clearly your body processes the alcohol different than everybody else's body that's alive.
Understood, yeah. I didn't do a good enough job prepping him.
You don't have
Because
to prep somebody to tell the truth. You don't have to prep somebody to tell the truth, the whole truth, and nothing but the truth. You
I
don't
should've
have to
been-
prep them. You don't
I
have
should
to
have been
prep.
more emphatic when
You should have, but he should not have lied.
I
Don't
feel
come
like
on
he
here
did.
lying. Don't come on my court lying. Don't come on here lying. All right, court is satisfied with the factual basis as well, and I will accept a guilty plea to 1 count of operating while visibly impaired.
Thank you.
You're welcome. The court is going to set the matter for sentencing. Mr. Flanagan, November 15th. How do I look?
Just 4 matters.
Court is going to set the matter for sentencing November the 15th. At 9:00 a.m. Sentencing is going to be in person.
Understood.
Put it on my docket, Mr. Flanagan, for 9:02.
Okay.
Prior to the sentencing, Mr. Hunt must submit to a pre-sentence investigation and a substance abuse evaluation through the probation department. Probation is going to contact you by telephone. If they cannot reach you, they're going to leave you a message and mail you a letter directing you to contact them. You must submit to the pre-sentence investigation prior to your sentencing so that I can have a proper pre-sentence investigation on the day of your sentencing. Bond will continue with no drinking and no driving without a valid license. Anything further?
No,
No,
thank you.
no, Your Honor.
All right, we're all set. Have a great day and stay safe.
Thank you again very kindly, Your Honor.
You're welcome.